All right. Well, welcome. So this is the first of a series of health policy and bioethics discussions that is co-sponsored by Portal, the Program on Regulation, Therapeutics, and Law at Brigham and Women's Hospital, the Center for Bioethics at Harvard Medical School, and the Petrie-Flom Center at Harvard Law School. We're going to talk today about the regulation of e-cigarettes with two very special guests, Abigail Friedman and Daniel Aaron, and moderated by our own Joseph Daval. I just wanted to alert you to that QR code on the screen there, where you can learn about the rest of the Center for Bioethics calendar. And I want to turn the floor over to my co-organizer. My name is Aaron Kesselheim, and I'm a professor of medicine at the Brigham. And I wanted to turn the floor over to my co-presenter or co-organizer, Leah Rand, who's a faculty member in the Center for Bioethics and a lecturer at Harvard and a research scientist at the Brigham in the Portal group with me. So, Leah, why don't you tell us about what are the goals of the seminar series?
Thank you. So this is a seminar series where we address current issues in health policy affecting health systems or public health and aim to draw out some of the ethical challenges in those areas and bring together experts with different disciplinary perspectives to understand the scope of the problems as well as potential solutions. And we hope that you will leave today knowing more and sparking new research ideas or policy areas and ethics areas that you want to do work in as well. So thank you for joining us. During this webinar, you are welcome to ask questions using the Q&A function, which is in the bottom of your screen in the Zoom controls. And we will be having a Q&A conversation towards the end of the webinar. If you have any technical issues, use the chat to send us a message. And our next seminar will be next month on October 10th, called Adoption on the Front Lines of Reproductive Justice, and we hope you will join us for that. So it's my great pleasure today to welcome our panel, and I will begin by introducing our moderator, Joseph Daval, who is a research scientist with the Program on Regulation, Therapeutics, and Law at Brigham and Women's Hospital, and he studies prescription drug law and policy. He received his JD from Yale Law School, where he served as an editor on the Yale Law Journal and has served as an attorney in the FDA Office of Chief Counsel. So Joseph, welcome, and over to you.
Thanks so much, Leah. I'm going to jump right in. In 2024, about 8% of high school students in the US reported e-cigarette use, which was a decline from 10% the year before, suggesting a moderate success of policy interventions aimed at decreasing use of e-cigarettes and vaping among youth. But evidence also suggests that while some interventions, like bans on flavored vapes, might decrease use among youth, these gains may come at the expense of increased use among adults of combustible tobacco products, which remains the leading cause of preventable death in the US. So today's discussion will reflect profound ethical trade-offs and questions about how government policymakers should prioritize the health of different populations. It will also address how policymakers' tools are threatened by an uncertain legal landscape. Earlier this year, the Supreme Court upheld the FDA's authority to deny pre-market authorization of electronic tobacco products, but the future of FDA's regulatory authority in this area is jeopardized by rulings that limit its interpretive authority over tobacco products and its ability to bring penalties against tobacco distributors and retailers. To help us understand these issues, we have two excellent panelists. Abigail Friedman is an associate professor in the Department of Health Policy and Management at the Yale School of Public Health. Her research focuses on the policy determinants of tobacco use and disparities therein, with the overarching goal of informing and facilitating evidence-based policymaking to improve population health and reduce inequality. Dr. Friedman received her PhD in the economics concentration of Harvard University's PhD program in health policy. Daniel Aaron is an associate professor of law at the S.J. Quinney College of Law, University of Utah. He received his JD from Harvard Law School and his MD from the Boston University Chebanian and Abedisian School of Medicine. His research examines how the law shapes life and death in the United States and the legal and social trends that explain the fall in American life expectancy. Dr. Aaron clerked for the U.S. Court of Appeals for the Sixth Circuit with Judge John K. Bush and served as an assistant chief counsel at the US Food and Drug Administration. And I think, Daniel, you're going to start us off with your slide, so I'll turn it over to you.
All right. Well, first, I want to thank Joseph and Leah for inviting me to join this webinar, also to Aaron, and also I'm super excited to be speaking alongside Abigail. I'm very curious to hear your thoughts and discuss with you in the Q&A. So I'll be talking about the structural barriers at the FDA to the regulation of e-cigarettes. So as Joseph noted, there has been some progress in the use of e-cigarettes among US high schoolers. And so in 2024, we saw 7.8% of high schoolers using e-cigarettes, which is a huge drop from the peak, which was thought to be in 2019. Although this is still quite a significant number of US youth using e-cigarettes. E-cigarettes are the #1 tobacco product used among US high schoolers, and so they remain a significant public health issue. E-cigarettes also carry risks. I'm sure many of you are familiar with these studies, but we've identified a number of chemicals associated with e-cigarettes, and e-cigarettes are associated with elevated heavy metal concentrations in the bloodstream, as well as various medical conditions, including asthma, COPD, coronary heart disease, etc. Of course, e-cigarettes also can deliver public health benefits, as the FDA has recognized, and so part of this depends on which population we're talking about, youth or adults. Nevertheless, I think the general goal of most people in the public health community is to try to, over time, eliminate tobacco use rather than and be cautious against replacing our cigarette epidemic with an e-cigarette epidemic, and hopefully trend both downward. So today, I will explore this key question: what explains some of the shortfalls in FDA regulation of e-cigarettes? I'll offer an incredibly brief history of tobacco in law, although we can expand a bit in the Q&A if people are interested. Then I'll identify 3 problems. #1 is the big windup of e-cigarette regulation. #2 is executive control, often presidential control over the FDA. And #3 is litigation, or kind of judicial control or interference with the FDA. So very, very brief history. This is a really remarkable chart coming from the Surgeon General, a 2000 report that kind of shows the long arc of cigarette consumption over the 1900s. Historian Alan Brandt has called the 1900s the cigarette century because of how impactful it was on American society and on how much consternation and debate and advocacy there was to try to bring down cigarette consumption. I can't understate the number of advocates and legal efforts and such that there were to try to address tobacco use in the United States. One of the most striking pieces of data that was influential in the regulation of cigarettes was this discovery, largely in the 1990s, that most tobacco use begins under age 18, right? So you have 88% of daily smokers starting to becoming daily smokers under age 18. And so this kind of disrupted a lot of the choice rhetoric that was used to justify why it was okay that people smoked and justify the addition of regulation for cigarettes. So FDA was a leader and tried to assert jurisdiction over tobacco, issued the 1996 rule, very creatively named rule, issued in 1996, which both asserted jurisdiction over cigarettes as both a drug and device, and had some substantive regulations of tobacco. Of course, the Supreme Court in FDA versus Brown and Williamson, in this famous case, declared that FDA could not have jurisdiction over cigarettes as a drug and device, which led to the Family Smoking Prevention and Tobacco Control Act of 2009. So essentially, Congress overruled the Supreme Court and provided FDA jurisdiction over tobacco products. This law was actually kind of controversial and split the public health community, many of whom were worried that having FDA regulation of tobacco would actually legitimate it. So it's kind of an interesting historical tidbit. The first finding of the law, in terms of its purpose, essentially, is that the use of tobacco products by the nation's children is a pediatric disease of considerable proportions that results in new generations of tobacco-dependent children and adults. Pediatric disease, that's very interesting and suggests that we really need to think about tobacco as a problem that starts in youth and that and demands some sort of regulation and intervention. So we have jurisdiction. The statute does a lot of things. It bans flavored cigarettes. It gives FDA pre-market review authority over tobacco products, kind of similar to drug review, but the standard is not safe and effective. It's appropriate for the protection of public health. Many new FDA authorities, including the authority to issue tobacco product standards and create sales restrictions on retailers, the mandatory reporting of harmful constituents, and ultimately a new federal-state balance of power in which the federal government has a much larger role in regulating tobacco. Okay, so there were several problems with the way that this statute set up tobacco regulation. So first, the problem number one is the big windup. And this results from something in the statute called the deeming provision, which said that this chapter shall apply to all cigarettes, cigarette tobacco, roll your own tobacco, and smokeless tobacco, and to any other tobacco products that the secretary by regulation deems to be subject to this chapter. In other words, FDA has authority over 4 categories of tobacco products and no other until FDA deems those other categories to be subject to the law. And so FDA did issue the deeming rule in 2016, which asserted FDA's authority over nearly all tobacco products. But you can notice that this is a 7-year gap. And this was a particularly challenging gap because FDA was setting up a new regulatory center, which took a huge amount of resources and thought and person time. And so a 7-year regulatory gap is a significant time period for new tobacco products to gain a foothold, and thus for FDA to kind of fall behind the mark as far as regulation. In addition, this deeming rule created some potential for gamesmanship because since there was a proposed rule, then tobacco companies have an opportunity to try to enter the market before the deeming rule, and thus kind of complicate FDA's effort to get a hold on the market. And so some companies did enter, particularly Juul entered in 2015, perhaps to avoid to be on the market in advance of the deeming rule to kind of have an advantage. And so the other thing I'll say is the deeming rule laid out a timetable for pre-market review to kind of get that rolling. But again, a lot of these products were already on the market, and so a lot of the review ended up being kind of post-market review as opposed to the statutory intent of pre-market review. Okay, so we had this really big windup. Finally, in 2016, we have the deeming rule, so that's a 7-year gap. And ultimately, even after FDA gains jurisdiction over e-cigarettes, there is this problem of executive control and the associated lobbying of the executive branch. So the deeming rule actually in addition to asserting FDA's authority over e-cigarettes, it also provided an opportunity for FDA to promulgate substantive regulations on e-cigarettes, right? Why not do 2 for 1, have other things in the deeming rule? And indeed, the deeming rule did have some substance, but one thing the deeming rule in its proposed form said is that it would ban flavored e-cigarettes, given the appeal of flavors to youth. So that was the draft. Then in 2016, Obama officials overruled the FDA after a lobbying blitz. And FDA ended up removing the flavor ban from the deeming rule on the grounds that it would hurt the economy, which is really not one of the rationales that FDA is supposed to consider in tobacco regulation. Nevertheless, you see the impact of executive intrusion in terms of interfering with e-cigarette regulation. This is an example of centralized regulatory review. So under Executive Order 12866 and some other executive orders, significant rules issued by agencies generally have to go through the White House, specifically the Office of Management and Budget, and its subsidiary office, the Office of Information and Regulatory Affairs, or OIRA. And of course, this all seems like a word salad to people who aren't in the law, but I can't stress how important these regulatory structures are in terms of affecting the final regulatory output, and the fact that the White House has a lot of control, and often regulations that go to OMB kind of just languish as a way for presidents to kind of control the regulation by just not clearing it. All right, so another example of this occurred during the Biden administration when the Biden administration kind of overruled the FDA and did not allow it to proceed with its menthol cigarette ban. And FDA had put a huge amount of regulatory time and work into moving forward with the menthol cigarette ban. And so we had this kind of crazy situation where the FDA commissioner, Dr. Robert Califf, was privately asking friends and public health experts to press their White House contacts over the status of the policy, right? So you have executive intrusion, and then you have the commissioner of the FDA telling people to pressure the president to allow the rule to go through, to allow the FDA to do its work, right? So kind of a crazy situation, but this is the kind of thing that you can see when there is such executive control over the output of our agencies. And presidential control over agencies is growing to the extent that you are all following Supreme Court cases of late. I have not updated this for the last few cases, so there are even more. But essentially, the Supreme Court right now is allowing greater and greater control, even of independent agencies. And so this is arguably putting more distance between agencies and their statutory missions and infusing politics into what is often supposed to be a public health and science-oriented process. And this table is from a paper that I'm working on, so it's not published. Another issue is control by the FDA commissioner. And you might say that, well, it makes sense to have a leader that kind of shapes the FDA's policy. On the other hand, FDA has pretty longstanding regulatory norms of having limited control of the FDA commissioner over decisions by the centers. And how much control should the FDA commissioner have? I think that's up for debate. But at minimum, we see the control by the FDA commissioner emerging as a serious regulatory impediment. So we had the deeming rule in 2016. FDA lays out a timetable for pre-market review. Then in 2017, we have the appointment of Dr. Scott Gottlieb as commissioner. And Dr. Gottlieb says, the Center for Tobacco Products has to reconsider the implementation of the deeming rule with an eye towards fostering innovation, where innovation could make a public health difference. So FDA issues a pre-market review compliance policy on behalf of innovation, which is quite deregulatory actually, and extends the e-cigarette submission deadline by 4 to 5 years and says that products can remain on the market indefinitely during review. So we have this commissioner who really believes in the value of unregulated e-cigarettes to contribute to public health, and therefore kind of indefinitely extends pre-market review essentially. And public health and medical organizations were not pleased. And actually, Dr. Gottlieb, just 1 year later, regretted this decision and said that we didn't predict what is now an epidemic of e-cigarette use among teenagers. So Dr. Gottlieb actually regrets it 1 year later and then actually becomes one of the most fervent kind of tobacco control advocates, which was quite an interesting reversal. And then in 2019, he resigns. And it kind of feels like he's maybe forced to. He says that it's because of his family. But you have to wonder whether he was ousted as a result of kind of becoming more regulatory in the tobacco space. Again, suggesting presidential control over the FDA commissioner. So this pre-market review compliance policy was actually deemed illegal in quite a stunning series of decisions by Judge Grimm in the District of Maryland, who said that the FDA is abdicating its statutory duty to review new tobacco products in the prompt fashion dictated by Congress. And the court kind of laid out its own pre-market review timetable, which is now solidified in tobacco regulatory history. But even though the court stepped in, we see executive control leading to big delays in the process. And then, of course, we have centralized litigation, right? So FDA did not have its own litigating authority. So our very own Joseph here on the webinar has this fantastic paper, Litigating Authority for the FDA, describing how the FDA is a captive client of the Department of Justice and actually cannot bring its own enforcement suits for the most part. And then this is a table of agencies that have independent litigating authority. HHS and FDA, of course, do not have such authority. And so you end up having the Department of Justice having a lot of control over FDA's enforcement actions. This became really important because Department of Justice appears to have nixed a lot of FDA enforcement actions during these critical times when e-cigarette regulation was kind of coming into fruition. And so actually the American Academy of Pediatrics goes back to the same court, and the court says that the state of affairs is inconsistent with its rulings. So we have this court kind of rebuking the FDA's lack of regulation. Of course, a lot of this stems from DOJ interference. And so we have a report from 2022 that criticized DOJ oversight and recommended that the Center for Tobacco Products actually work around the DOJ, which is kind of a stunning recommendation to kind of work around the legal constraints given DOJ's acting as an impediment. And I just want to stress that during all of these battles, we see e-cigarette use among US youth rising, Surgeon General declaring in 2016 that e-cigarettes use among youth is a major public health concern. And in 2018, the Surgeon General declaring an epidemic, right? So these rises are occurring alongside this executive intrusion and regulatory battles. Okay, the third problem is litigation. I have this paper in the Seton Hall Law Review from a symposium. The paper is called Loper Brights Deregulatory Synergies. And basically, I go through all of these deregulatory changes that are occurring in US law. I do not have the time to even start to address all of these, but I just think it's worth emphasizing the role, particularly of the Supreme Court, but also other courts in impairing the FDA's core work. And so, number one is that when FDA was denying the marketing for a lot of tobacco products, there was an overwhelming amount of litigation lodged against the FDA, which in my view was kind of cynical, kind of turning to the courts to circumvent regulatory authority and public health. And this overwhelming amount of litigation definitely affected the morale of FDA attorneys who were just swamped with work. Nevertheless, FDA did essentially have a tremendous victory. This culminated in a case just that was decided a few months ago, FDA versus Wages and White Lion Investments, which was a challenge to FDA denials of flavored e-cigarette products. There was a court decision in Texas from the Fifth Circuit that painted the FDA as unprincipled and internally contradictory. The Supreme Court agreed with FDA in full and said that FDA did not mislead tobacco companies about regulatory expectations and otherwise agreed with the FDA. Interestingly, to my eye, this was a pretty easy case. I discussed this in a perspective piece in the New England Journal of Medicine, e-cigarettes at the Supreme Court. And this is a piece by Erica Litson, Nothing to See Here, Move Along, which highlights that this really was an easy case. Nevertheless, if it had come out the other way, this would have been devastating for the FDA's scientific decision-making. And so this is kind of a larger lesson about the Supreme Court. Yes, giving a decision for FDA and for agencies occasionally, but writ large, shaping the law in a way that undermines regulatory action, in my view. Next, we have the case FDA versus R.J. Reynolds Vapor Company. Again, a Supreme Court decision that, and the course of this litigation is a threat to FDA's regulation. So basically, tobacco companies are challenging their denials in anti-regulatory courts in Texas. You're going to see a theme that all these challenges seem to be brought in Texas. I mean, there are tobacco decisions in other circuits, but there is a trend to bringing them in Texas. And the strategy that tobacco companies are using is there's this provision in the Tobacco Control Act that says that any person adversely affected by a denial can sue in DC or their home circuit. So that means that if you're based, say, in North Carolina, then you have to sue in DC or the Fourth Circuit, which is around that area. But instead, tobacco companies are partnering with convenience stores in Texas to file joint suits challenging the denials so that they can forum shop into friendly Texas courts. FDA criticized that before the Supreme Court, said that this is nullifying the language of the Tobacco Control Act, allowing this unjustified forum shopping. The Supreme Court said, ultimately, it decided half the case ultimately. So the Supreme Court said, okay, these retailers are within the zone of interest of the people protected by these statutory provisions, and therefore they can sue, which leads to kind of an odd result that any convenience store can sue for denial of any product, it seems, since they would lose the opportunity to sell the product. But the Supreme Court did not answer the other question, which is whether each manufacturer and retailer must independently establish venue in the particular location in order to sue in Texas. So the case has been remanded to decide this final issue. But if decided against FDA, then FDA is going to see even more cases brought in anti-regulatory courts. and kind of this forum shopping and judge shopping. Lastly, there is Walfurnick versus FDA. Now, this is a case about civil monetary penalties. This is one of the only enforcement areas where FDA does not have to go through the Department of Justice, although they do have to go through the DOJ for appeals of civil monetary penalties. And the court held that the civil monetary penalty provisions were unconstitutional, which is a really stunning result. FDA was seeking a mere $20,000 penalty for selling unauthorized products. And so this has to do with a Supreme Court case that weakened agency adjudications, a case called Jarkissi. I realize I'm almost out of time, so I'm going to speed through. But basically the right to a jury trial, so that if there's an adjudication in an agency, well, you don't have a jury before that, so that you can't do the proceeding at all. And this may, if FDA does an appeal, or if FDA loses on appeal, force FDA to go to jury trials and essentially rely again on DOJ. Where do we go from here? There's the prospect of state enforcement. I'm going to skip through a little bit for time. I just want to emphasize that even though state regulation is a really important issue, I don't think it's enough. I think it's very vital to have a robust regulatory framework, and for FDA to receive the structural support to uniformly improve public health around the country, especially given that states have very limited resources. So that it could involve various ways of giving FDA more funding or independence. And ultimately, FDA has this really big authority to issue tobacco product standards that it has never used. We do not have a single tobacco product standard since 2009, highlighting the impact of regulatory interference. Lastly, I have a symposium that I am throwing called Fireproofing the FDA: Power, Politics, and Public Health. If you want to learn more about structural issues at the FDA, this is at the University of Utah, although you can attend over Zoom and it's free, covered by my grant. I do receive funding from Arnold Ventures. But this is going to be a great symposium, and Joseph is actually speaking. It's mostly law people, but I hope you can attend. So with that, thank you, and my cat Dolly says hi.
Thanks so much, Daniel. That was great. I'm going to turn it over to Abigail.
Hi, everyone, and thank you for having me. Thank you, Daniel, for an excellent presentation. You've covered some of what I was going to cover, so I'm going to edit in real time. There's no slides here because since I didn't know exactly what Daniel was going to say, I figured there'd be redundancies if I did it that way. Let's jump in. This is a huge subject, and given the range of groups that are sponsoring this, I kind of chose one and started to focus on bioethics. So the question I wanted to ask was, fundamentally, how should e-cigarettes be regulated from an ethical perspective? And is FDA's approach to reviewing and regulating vaping products appropriate for public health? And then as a corollary, if so, do they have the resources and authority to actually carry that out? So to get at these, I was going to give you a background. I'm going to make it brief because Daniel covered most of it. E-cigarettes entered the US around 2006, 2007, depending on your source. And the market really kicked off in 2012, which is when Lorillard bought the company Blue e-cigarettes. FDA's authority to to regulate the manufacture, distribution, and marketing of tobacco products stems from the TCA, a 2009 law, as Daniel says, but because e-cigarettes weren't deemed to be a tobacco product until 2016, effectively, FDA powers in that space were limited to unclear, right? There was some legal action early on, but really there was no overt regulation of e-cigarettes until that deeming rule at the federal level by FDA, because it wasn't clear they had that power. All right, so when we talk about FDA regulation of vapes, what this means is we're talking about the last 10 years, right? It's important to understand that context. Now, the other piece of context we need to talk about this is how should we think about vapes in the context of tobacco products? There's a 2022 paper by Hunt Alcott and Charlie Rafkin that found, after surveying about 137 tobacco experts that don't have ties to the industry, that the average expert perceived the harm from e-cigarettes to be about 2/5 the harm from smoking. Okay, now let's be clear. Combustible tobacco use has been the leading cause of preventable disease and mortality in the US for half a century, so 2/5 the harm of that is still not safe. But what this tells us is that the impact of e-cigarettes on public health depends on how they affect combustible product use. And there's a substantial, at this point, body of evidence demonstrating that e-cigarettes and cigarettes are economic substitutes. What that means is if you make one of these products more expensive, less accessible, or less appealing, you'll see increased use of the other. And that's been borne out in studies across all age groups looking at taxes. When we raise taxes on e-cigarettes, yes, we see less e-cigarette use, we see more combustible cigarette use, right? If e-cigarettes are substitutes for combustible tobacco products, then regulations restricting the former may increase use of the latter, and we have to consider that in any regulatory approach to e-cigarettes if we want to promote public health. There's also a myriad of research pointing to e-cigarettes as an effective smoking cessation aid. There's Cochrane reviews of randomized controlled trials that show that nicotine vapes increase cessation rates compared to nicotine replacement therapy, FDA approved. And there's a 2024 double-blinded RCT published in JAMA Medicine, which found that the impacts of e-cigarettes on smoking cessation were similar to the impacts of varenicline. Now, for context, if you go to the CDC website, it states that varenicline is a smoker's best chance of quitting if you're using a single medication. So if e-cigarettes are similar to varenicline, if that's borne out, that's a major finding. What this tells us is that the appropriate regulation of e-cigarettes for public health depends on context. What other products are available in the market, whether the population in question is using or likely to use the more lethal options that are substitutes, and in particular, how the regulation is built to shift as that changes. If we're thinking about disparities, the lens I would use here is we know from decades of research that lower socioeconomic status populations are more likely to use combustible tobacco. So it's plausible that stricter regulation of e-cigarettes could be more harmful to that group than higher SES groups where they were unlikely to use the combustible products in the first place. How do we think about that? This brings me to the second question. Is FDA regulation of e-cigarettes appropriate for public health? So keeping in mind that optimal regulation probably depends on context, right? If we were in a world with no combustible products, this would be a much simpler question and conversation than a world with combustible products. We need to think about FDA's regulation of e-cigarettes then in the context of how it regulates combustible products like cigars and cigarettes. And FDA is really limited on the e-cigarette front. First of all, the FD&C Act, Food, Drug, and Cosmetic Act, which was amended by the Tobacco Control Act, doesn't assess user fees on e-cigarettes. So the ability and the funding to support regulation against e-cigarettes is not growing with the market power of that particular product, right? Or excuse me, the companies for that particular product. So the load grows, the amount they have to regulate and what they're tackling grows, the amount of funds they have do not grow proportionally. That's a major constraint, right? The FDA is much smaller in terms of the amount of money it gets for the Center of Tobacco Products every year than Juul or Altria or Reynolds. So we're working on different scales. Secondly, for FDA to review a product, if we're talking about a particular e-cigarette product, they have to have the product be submitted as a pre-market tobacco product application, resource intensive for the firms, and they need to demonstrate, the firms need to demonstrate that it's appropriate for the protection of public health. That's a heavy lift for the firms. It's a particularly heavy lift for FDA. FDA has reviewed, I believe it's over 20,000 of these products. And to date, millions have been denied marketing authorization. A little over 20 have been authorized. All right. On the other hand, let's talk about combustible tobacco products. There's a simpler pathway. Because e-cigarettes weren't factored in when the Tobacco Control Act was passed, this isn't relevant to that. But the Tobacco Control Act basically created a pathway called substantial equivalence, where if you can show that your product is substantially equivalent to something that was on the market prior to February 2007, or substantially equivalent to a predicate, a product that was approved under that pathway, then it's a much more streamlined path. It doesn't go through this full review. And consequently, getting a cigarette on the market today is actually a much easier proposition in terms of FDA than it is to get an e-cigarette on. The resources are just required are much lower. What this means is that effectively, FDA regulatory structure at the moment is friendlier to the introduction of new combustible products than it is to the introduction of new e-cigarettes. And I would argue that by definition, that status is not appropriate for the protection of public health. But again, the substantial equivalence pathway was defined in the TCA in an amendment to the Food, Drug, and Cosmetic Act. FDA can't change this. Congress has to. So you may be wondering, if FDA is so constrained in its review of these products, why are there, or excuse me, so constraining in its review of these products? They've only, approved 20 some of them. Why are there so many of them on the market when I walk into a 7-Eleven or in my town? There's a lot of reasons for this, many of which Daniel just covered in terms of regulatory and litigation. Another factor here is the billions of dollars in annual revenue that exist in this market. So if we were in a world where the civil monetary penalties weren't challenged, which Daniel raised this challenge a moment ago about civil monetary penalties even being an action that FDA can take going forward. If we assumed that wasn't in question, FDA is still capped at about $21,000 for these penalties in a market that's $1 billion more, per more than $1 billion every year. So FDA's ability to put forward a penalty of that size, it's not clear that that is impactful enough to move the needle for these firms when it is such a profitable market. And the fact that FDA can do very little besides that without cooperation from either Customs and Border Protection or Justice is a real limit on what they can be effective doing. So I want to bring up at least one more question here, which is Tobacco 21. Let's talk about a different FDA policy that's also geared towards limiting e-cigarette, but also combustible tobacco product use. Now, Tobacco 21 was passed nationally at the end of 2019, but FDA didn't release the final rule until 2024, which is its own can of worms. But you may ask yourself, why would we expect minimum legal sales ages to work, given the current regulatory status? And what does that tell us about why e-cigarette regulation at FDA might be not working as well? In the case of minimum legal sales ages, the states have to demonstrate compliance to get the substance abuse prevention and treatment block grants. So there is a lot of money that the states will lose if they cannot demonstrate compliance with minimum legal sales age laws for FDA, which leads to a strong incentive for states to run compliance checks and try to enforce this. And it's not perfectly enforced, but it is a reason that we would expect this to work. That same structure is not yet in effect, or a structure like that is not in effect for e-cigarettes, right? The states do not have a huge chunk of money to lose if they fail to enforce regulations or prioritize restrictions on products that haven't got FDA authorization. Until there is an on-the-ground incentive for enforcement, the incentive is big enough and funded well enough relative to the benefit that the retailers are getting, and the incentives are aligned in a way where they actually make sense for public health, not just for one group, but for everyone, it's going to be very difficult for FDA to be effective in regulating these products on the ground. So, high-level summary, the structure that FDA has for regulating e-cigarettes was tacked on to a structure that did not originally include them, which hampers FDA's ability to be effective in this space, both from a perspective of funding, from a perspective of enforcement mechanisms, and from a perspective of authority, right? In many ways, changing that is going to require congressional action. And at the same time, the right way to regulate e-cigarettes depends on context. It depends on what people would be doing if you didn't have them on the market versus are doing with them on the market. Are we going to move people towards less harmful products, harm reduction, or more harmful products? Right now, the groups that smoke that smoke cigarettes at the highest rates in the US are adults, right? So if we look, for example, at 18 to 54-year-olds, or actually let's cut it more, 21 to 34-year-olds, about 12% of them use a combustible tobacco product. That's a cigarette or a cigar. 35 to 54-year-olds, it's 17%. So those 35 to 54-year-olds, that's the group that's going to die in the next 20 to 30 years if they don't quit. So if we're talking about mortality in the short run from combustible tobacco products, the group that would likely benefit from moving towards a less harmful product in the near term, we're talking about that group, and they still smoke at a decently high rate. Not what it was 20 years ago, but more than 1 in 10. So when we think about how we're regulating this, yes, we have to think about youth. That's the logic behind Tobacco 21 laws, among other policies, but we also have to think about their parents, because those 35 to 54-year-olds, they also have kids. And something happening to them has implications for youth as well. This is what makes it so complicated, and I look forward to a broader discussion because I think this is a fascinating area, and I love that we brought together people from different disciplines to think it through. Thanks.
Thanks so much, Abigail. That was great. A reminder to everyone to keep sending in questions to the Q&A that our excellent panelists can answer. I'll kick it off with, I want to get you guys to talk a bit about what would a more effective regulatory strategy be at the federal level. So I think there's kind of, I'm hearing general agreement around consistent funding for the FDA. You know, let's assume a willing Congress that will kind of pass the regulatory regime that you want them to. Assume a deferential judiciary, none of the kind of civil monetary penalty jargony problems. Assume that FDA has the regulatory authority that you would want it to. Does that look like a pre-market system plus better enforcement like what we have now? Like just make the fines higher and there's kind of a, and more consistent, and there's a magic level where now everything's okay? Or is that basic framework of like pre-market approval and post-market enforcement, is there something wrong about that itself and we can imagine a better system?
So I actually think that the better system starts with sunsetting combustible products. Right now, the burden that a firm has to introduce a new combustible product is very low relative to e-cigarettes. And those are the products that we're talking about when we're talking about killing people in large numbers for decades. Even if you take out the for decades, even just during the last decade, right? Tobacco product use is estimated to kill as many, or to be, smoking attributable deaths. So deaths attributable to tobacco product use are estimated to kill the same number of people in the US every year as died in the first year of COVID. All right, so this is a huge burden of disease. Getting the regulations right for e-cigarettes depends on how many people are using the more lethal products that they may leave in favor of e-cigarettes. So as long as we've got a structure that is allowing, essentially grandfathering in products that are incredibly harmful just because they happen to be on the market before a certain date, that's going to make products like e-cigarettes seem like they need to stay on the market as a harm-reducing technique. The harm-reducing technique only exists if there's much more harmful products around. So to me, the first step has to be sunsetting these large-scale combustible products and getting people the support they need to move down the level of harm that they're imposed on by others around them or imposed on themselves. There's a tendency to think of tobacco, as nicotine in particular, as being much less addictive than it is if you've never smoked. Nicotine is an incredibly addictive substance. It's also not the primary cause of the health problems associated with smoking. So when we have nicotine e-cigarettes, nicotine pouches, we shouldn't be thinking of them as exactly the same thing as a cigarette. As long as cigarettes and cigars are on the market, this calculus is much more complicated. How do we regulate those other products than it would be if we were serious about getting those products off the market?
You're on mute, Daniel.
I'm muted, yes. I just want to say Abigail's presentation was fantastic, and I agree that we really should focus on sunsetting combustibles. In fact, the FDA was partially trying to do that with its menthol cigarette ban proposal. Of course, again, that was subject to executive intrusion. Of course, that would only apply to menthol cigarettes, but that is one of the more addicting forms of cigarettes. And so I think that would have been a step in that direction. In terms of whether pre-market review is an ideal regulatory approach, I do think that there was a sensibility to what the drafters of the statute were trying to do, in the sense that we see in the drug space that pre-market review is a really strong way of keeping unauthorized products off the market. In fact, there are these norms that if a drug isn't approved, it cannot be sold. And so FDA doesn't even have to take that many enforcement actions to kind of enforce these pre-existing norms. And in fact, I think a doctor would be hesitant to prescribe a drug that was unapproved for the most part. On the other hand, with tobacco, we see that there really isn't a norm of following the pre-market review requirement, and companies openly sell their products even when they are not authorized. And so part of a regulatory system should build toward establishing those norms that the law matters, the rule of law matters, and these companies have to fulfill their legal obligations of getting authorization before they sell their products. I also agree with Abigail that there is an unfortunate aspect of the way that the statute structured pre-market review, including that it has the substantial equivalence pathway for combustibles. That is viewed by many in the public health community as a really serious statutory flaw. And in my view, it may be explained by the fact that the cigarette industry was actually on board with the Tobacco Control Act and perhaps needed to be on board for the law to move forward, which says something about the way that business interests infuse themselves into the legislative process. But of course, if we had an ideal pre-market review pathway, you wouldn't have this very large hole that applies to combustible products. You also wouldn't have the hole that existed that allowed e-cigarettes to just go unregulated through the deeming provision. So there were actually two holes, one that applied to older products and one that applied to new products, both of which negatively impacted the public health impact of pre-market review.
Can we dream for a second?
Dream away.
Yeah.
In a dream world, there would be a concrete standard for any product that's reviewed by FDA, where if it doesn't meet that standard, it can't even be, there's no pass go, right? If there's mercury in the e-liquid, right? There's some kind of concrete standard where we say we're going to be internally consistent across products. If it causes more harm for this, and it's not a pharmaceutical where you're already treating a very harmful disease, right? We don't want to judge chemo the same way. If there were that concrete standard, we could have a very clear conversation of, before you get to how this affects use of other products and trade-offs, this doesn't pass go or it does. And without that concrete standard, the pre-market review process is incredibly onerous on everyone involved, right? They have to create this firms have to create a huge set of documentation to prove that it's appropriate for public health, but they don't know what they're trying to reach. The innovators don't have a goal if they're trying to generate a product that actually meets the standard. If we had a concrete standard, we could also change it over time. What's acceptable in 1999 shouldn't be acceptable in 2019 in terms of what's normal for these products. The lack of a concrete standard creates opportunities for judicial challenge, right? If the standard existed, if it was held, whatever reason, lots of ifs, then FDA could very clearly demonstrate it does or does not meet the standard before we had any question about substitution between products and effects on different groups. Without that, it's kind of hard to figure out why we should or should not be approaching review the way FDA is, right? Like what is too dangerous? And it would be, I think, useful because we could then also apply this to other areas, because there are lots of products that are dangerous on the market. But without that common standard, it's kind of hard to say, everything seems like it might be open to litigation.
Yeah, it's a great question. I had this question as well. I realize it's a legal question. Maybe this is something Daniel can add. The statutory language is appropriate for the protection of public health. What does that mean? Appropriate in whose determination, as judged against what standards? Like, do we have a sense of kind of what the intent of the drafting was, how it's been interpreted over time, what flexibility FDA has to interpret that language? What are the answers here?
That's a lot. Well, the first thing I want to say is that Abigail mentioned the importance of context in the evaluation of tobacco products' public health impact. And I think the trade-off here is you could have a very clear standard like no mercury, but if you want to consider the larger circumstances of tobacco products and what products are on the market, the current standard allows FDA to consider that. And I think there are serious pros to that and serious cons to that as well. But in that determination, FDA considers a variety of things like the chemicals inside the product, the chemicals of other comparable products, the likelihood of switching among different populations, including youth and adults, the probability of adopting the product among non-users. So there are kind of a variety of considerations. But interestingly, the FDA does explicitly consider, are people going to switch to this product from a more harmful product, from a less harmful product? Or are non-users going to start using this product, and at what rates? So in that sense, FDA is trying to do a contextual determination. One good thing about the fact that this standard is so public health and science laden means that although we have seen a lot of court challenges, FDA just had this huge victory in wages and white wine. And I think that's because the Supreme Court was very hesitant to overrule the FDA's scientific authority, whereas it's been very keen on hampering agencies' legal authorities.
So
And so, oh, go ahead. No, Abigail,
I want
please.
to push back on something. So Brian King, who was the past director of the Center for Tobacco Products, has said publicly that he needs more than quasi-experimental evidence, than these population-wide studies that get causal effects without randomization, that look in the population when a state puts a flavor restriction in effect, when a state taxes these products, when a state limits the age at which kids can buy e-cigarettes, what happens to use of e-cigarettes versus smoking in these states. These studies have been replicated by lots of different teams on lots of different data sets, and they are consistently finding the same thing, which is the more you restrict e-cigarettes, make them less appealing, less accessible, or more expensive, the more you see use of combustibles. If FDA is not considering that evidence, which was the line that we were getting when presenting that kind of evidence a year ago, then they're not considering all the evidence about the trade-offs between individuals. The bar seems to be not inclusive enough of population-wide evidence. Now, RCTs are great and wonderful, expensive, but randomized controlled trials are very useful, but they don't necessarily generalize to an entire population, because the people in the RCT know they're being watched. It's called a Hawthorne effect. It changes your behavior. If we can't use a body of evidence that ex ante sends to kind of say something different than what we've been seeing FDA do, there's an open question here of whether FDA is consulting all the evidence. But at the same time, I feel like we have to be very clear-eyed about the resources FDA has to go through with this and about the powers FDA has. I would put an asterisk on the idea of FDA is considering all of these other effects, because I don't think that that is necessarily comprehensively being considered in the way that many academics would like it to be.
So I think one thing that's really interesting about what you said, Abigail, is we do have this individualized process for individual products, or groups of products by the same manufacturer. And so there's this question, should we actually not do such an individualized process and kind of do something more population based? To a degree, I think FDA does consider some population based evidence, but I don't know exactly which kinds of population based evidence they are not willing to consider, as you say. But if you apply this population-based evidence that you're citing broadly, then would that mean that the individualized inquiry kind of goes away and that all these products would go onto the market? And so perhaps this is part of the way that the review is structured. Honestly, though, I think it might make more sense in some ways to do review at a larger level so that you do reduce the burden on these products. Although I think that there are also some differences among the products that could affect the public health impact, rather than kind of saying e-cigarettes writ large. Like, I don't know if, disposables seem to be very appealing to youth right now, certain colors or certain marketing schemes, right? So there are some individualized factors. What do you think, Abigail?
I think we need a two-step process, quite frankly. I think that none of FDA's effort should not be expended to look at the comparative effects in the market at large if you haven't passed the is it safer than X test. Give us a standard where you don't pass go, smaller fee, still a fee to send in your evidence. But if you don't pass that standard, you don't get the broader review that looks at the effect in the market. The problem is, what we know to be true is the effect of one product, if it depends on context and we're looking at one product at a time, it's missing the effect of, are there products that look like X, have this flavor, disposable, whatever? Are there products available at all? You could review products one by one, come to a solution where no products are available, and suddenly have a worse outcome than if one or two of those products had been on the market, depending on how people substitute, right? And let me also say, all of the current literature might change if there were an e-cigarette approved through the CEDAR pathway as a cessation device. If there were products on the market covered by insurers that were e-cigarettes specifically for cessation, and they had flavored versions, then the trade-offs get very different in how you regulate the products that are generally available versus available with a prescription. So at the end of the day, I think this is intensely complicated. The simplest thing I can think of to make it a little bit easier is have a standard, allow FDA or Congress, whomever, to update that standard of this is too dangerous to even get to the next level of review, and start funding FDA with user fees from e-cigarettes so that they actually have the resources to conduct their review appropriately.
Can I say one thing about your last point? I thought this was phenomenal. The idea of funding e-cigarette regulation through user fees, well, you could actually argue that because FDA is not charging e-cigarette companies for user fees, that's actually kind of transferring some of the tax burden from e-cigarette companies to cigarette companies, if that makes sense. And therefore, in that sense, the regulatory system is actually in favor of making combustibles more expensive. And whereas FDA can actually use those user fees more broadly if it wants to. And it does do e-cigarette regulation on the backs of cigarette companies. So in that sense, I think
they're the same, right? Like
with
with the caveat that with the exception of like the large influx of disposable flavored vapes that we're seeing from Shenzhen, China, a lot of the companies that produce e-cigarettes are the companies that produce cigarettes, right? Reynolds sells,
well, sure.
Right. So
perhaps they just even it out.
Yeah, there's
to a degree.
The economist in me is like, hey, let's do a supply side analysis and understand that.
All right,
There's another element here.
In the interest
probably
of
about
time, I really let something loose there. In the interest of time, I'm gonna we have 3 questions in particular that I want to get some reactions to. I'm gonna put them all together, and then we'll go to each of you just to get some reactions on whatever you think is interesting from them. The first is about compounds other than nicotine. Is there a risk that compounds other than nicotine could be delivered with technologies similar to e-cigarettes? If so, how would that alter that discussion? And in particular, I'm thinking on a regulatory level, is it plausible to claim that those are tobacco products subject to the Tobacco Control Act if they don't necessarily contain nicotine? The second question is about taxing e-cigarettes versus combustibles. This is something, Abigail, that you were talking about a bit. Maybe this is something you can speak to, kind of what the ethics are of kind of trying to engineer switch in one direction or the other. And the last question is about regulations on marketing and point of sale restrictions to minors.
Okay. I'll take a swing. Does that make sense? If I can keep track of them. So the first one was if the device can be used with different products.
Yeah, different compounds other than nicotine.
So like in theory, but the viscosity of the e-liquid and a lot of these refillable devices is not the viscosity of, I assume they're thinking cannabis e-liquid. So for the most part, you would be using different devices for that. But if they're put forward as for use with nicotine, then they are subject to that pathway. This is about the device versus the e-liquid, though. Remember, people are using disposable devices. They're selling them with the e-liquid already in it. So it already has nicotine in it. That's why it's going through the pathway. If it's a reusable device or refillable device, which is actually not as popular as the disposables these days, then you're talking about a product that still is being marketed for sales in a certain way. And it can't exactly be marketed to the federal government for sales with cannabis because cannabis is still legal federally. That's where I would put that. If you're talking, but yes, if I take my coffee mug and I put tea in it, it's not holding coffee, right? If you take any device and you put something that wasn't intended for it, may or may not work, maybe other problems, maybe the device, maybe what you put in it was breaking down the metal and you've got a whole new set of problems. But there's a certain amount of user agency that cannot be accounted for and a certain amount that can. With respect to taxes, the evidence is pretty clear that when you tax cigarettes, you see more e-cigarette use. When you tax e-cigarettes, you see more cigarette use. And that probably means that we need to set up taxes in such a way that they're both not appealing, but one of them is less not appealing than the other. Generally, the way I put it is it should be more expensive to use a more lethal product. And when you change,
I'm gonna cut you off real quick just to because we're at time to get some quick thoughts from Daniel. If you have anything to add here.
This was so good that I actually forgot the questions 2 and 3. But for number 1, which I apologize, but for compounds other than nicotine, I don't think that there's a plausible argument that if there's no nicotine or tobacco involved, that there's a tobacco product, since a tobacco product is something made or derived from tobacco or containing nicotine, even if it's synthetic. That said, I agree with Abigail that a product that is intended to be used with tobacco or nicotine in some way that is used for something else as well could be brought within, or is likely within, the scope of the statute. That said, again, I forget questions number 2 and 3, but I've had a great time today at this webinar.
Thank you both so much. This has been a great discussion. Leah, I'll turn it back to you.
Yes, I want to thank the three of you, Professors Friedman, Aaron, Daval. It's wonderful to have you here, and I wish we had more time to continue the conversation. And thank you to everyone who joined in, and I hope you will join us in October as well.
Thank you very much.
Thank you all.
Bye.